the campaign. First, I want to confirm that we have received invitation to participate in the audit of the team kits. In fact, our team is there today, and we thank the Commission for that. And we have also received the invitation to submit names of those who will travel to Greece. However, we are still concerned that there's still back and forth regarding this issue of a complementary system. And I think a clear communication should be made to the public of what this means. The best situation for us would be just to say that we shall have a voting process as we did in the last election. And if the Commission will not change how it dealt with the election in the last election, I think that would be the best communication, because then there was no fight as to what system was being used. I want, however, to come to the issue of the printing of the ballots that have already been done. And I think this goes to the Secretariat, because I believe it is them who give the order to the printer. Regulation 52 requires the chairman to publish a gazette of the names of candidates. As of now, that gazette has not been published. We have heard that the explanation for the Commission is that that has been submitted to the government printer. However, the law is that until that gazette comes out, then you do not have a legitimate list of candidates as of today. And there is proper case law on that, and people will remember the case of the Kiambu County, who attempted to act on a legislation before it was put in the Kenya Gazette, and that legislation was quoted as illegitimate. So as we stand now, ballots have been printed for candidates who have not been gazetted, and without gazettement, it means then that there are no legitimate candidates for those positions that you have printed ballots. And a constitutional issue therefore arises as to whether what you have printed can legitimately be termed as a ballot within the Constitution. How are you going to deal with that legitimacy crisis? Because until that gazette notice comes out, all the people who you have declared to be candidates will not legally be candidates until they're gazetted. Thank you.
Yeah, we can deal with those ones. Can we finish with those ones? Then we take another round. Publication of audit report. We were in this room last time and gave a press on the release of the audit report. Pursuant to that, what the Commission has then done is ask the CEO to prepare a matrix or a write-up on what the Commission has done to implement that audit report, which we want shared then with the relevant stakeholders in terms of the law. We realize that we are in a country where there's a lot of misinformation, disinformation, and a skewed flow of information. So we want to circulate that audit report to the relevant institutions together with our matrix of compliance or enforcement of the recommendations of the audit report. And I think Mr. Marjan, I don't know when he'll be ready with that, but it's in the course of, he's in the course of sharing that with the relevant institutions. So it will be shared with the relevant institutions together with the matrix of compliance by the Commission. What lists when? Don't know who is Director Legal here? Yes, you answer that question. I've not seen the report on the party list. You come and say when it's ready. Officials, in the legal report, the officials involved are five. Five officials are involved from the report which we have shared with the DPP. And DPP, I'm sure, will take the relevant action. The names of candidates, and I believe this goes with the question by Mr. Mwangi, Paul Mwangi, on the Gazette, the Gazette notice. The Commission submitted the names of the 16,000 candidates to the government printer. And that was on 30th of June. We understand there were logistical challenges, including breakdown of equipment at the government printer, and that's why it has taken a bit of time. But I believe the CEO has been in touch with the printer. You can shed light on that. And legal director, maybe you can also comment on the case referred to, Kiambu County case, Regulation 52. Complementary system, the discourse in the last meeting, Mr. Mwangi, I think we were with you at Windsor, and we had a conversation on this matter. I thought we had a good conversation.
I thought so too.
Yes, and the way forward was we proceed to print the register, but we await the outcome of the court as to the way forward on the matter of physical register versus the digital register. But what I've seen in the media is the opposite of that. Maybe we need to have that conversation again, because at this rate, then we are not waiting for the court case. We are having conversations through public rallies, and then the commission is put in a situation where we really don't know what to say. But I thought we said, let's print the register, wait for the court determination, then we follow through. But perhaps we could then have another meeting with the stakeholders and find a way forward, because this is our country. We don't have another country. We need to be on the same page as we move towards this process. So I would be recommending, and we shall be discussing the commission on the possibility of another meeting to finalize on that issue. If we can't wait for the court case, then I'm sure we can come up with a solution one way or another. The ruling by Mr. Justice Murima vis-a-vis presidential candidates. Again, our Director Legal is here. Would you want to take that up? Yes. So we, and then I'll invite the commissioners if any of them has anything to add. We.
Thank you, Chairman. I'll respond to the three questions. The first one is on gazettement of the candidates. The Commission Chairperson signed the Gazette notice on the candidates on the 30th of June, 2022, and the same was transmitted to the government printer. Now, the government printer has been working day and night to ensure that the notice is published in good time. As at yesterday, there was a slight problem, on the photographs of the candidates. That is, the notice has to come out with the photographs of the candidates. So this morning, the government printer indicated that it was almost done with the transposition of the photographs, and that the notice would be out in good time. The notice is dated 30th of June. The case law that has been cited by Senior Mwangi, I have had occasion to peruse, and it is about gazettement of legislation that was passed by the County Assembly of Kiambu. It is not in respect to candidates' gazettement per se. On the issue of party list, the Elections Act is extensive on the framework of processing party lists. Now, the last day of receipt of the party list was on the 25th of June, 2022. The Commission then, by law, has a period of 14 days within which to review the party lists submitted by the political parties. A total of 79 political parties intending to participate in the elections submitted their party lists. So as we speak, there's a technical team that is reviewing the party lists, and by 9th of July, which is the end date of the 14 days prescribed by law, there will be a report on compliance and non-compliance. The commission will then write to the political parties that have not complied with the checklist on party lists. And the political parties will have 7 days, as prescribed again by law, within which to now revise, and not to review, to revise their lists. So from 9th of July, add 7 days, that takes us to 16th of July. So that is the date, that the last date that the political parties will resubmit the revised lists in compliance. The commission will go through the lists again, and if any is found to be non-compliant, then the same will be rejected in total. Now, those that will be found to be in compliance will be published in at least 2 newspapers of national circulation for the public to have a view of all those persons who have been proposed in the party lists by political parties. A notice will then be published by the commission on dispute resolution. So any party member who is aggrieved by the list that will then be published is at liberty to lodge a complaint with the commission's dispute resolution committee on grounds of probably non-inclusion or discrimination or whatever grounds. Now, the commission will only be seized of the mandate to resolve a dispute that touches on non-compliance with the statutory provisions. But if it's a dispute between a member of a party against his party for non-inclusion, then that dispute will be heard and determined by the political party's disputes tribunal. So we have 2 sets of disputes, presided over by the IEBC Dispute Resolution Committee, and another set presided over by the political party's disputes tribunal. On the judgment on supporters of independent candidates and supporters of presidential candidates furnishing the commission with copies of the identification cards, the judge on Tuesday delivered a brief judgment, a brief text of the judgment, and yesterday he delivered a full text judgment. We've gone through the judgment, and there are 4 declaratory orders that have been issued. Of course, the case was a consolidation of several cases with petitioners running up to 18 in number. Part of the case revolved around prayers that provisions of the Political Parties Act on independent candidates are discriminatory insofar as they do not provide for a coalition of independent candidates. There is the limb that touched on the copies of supporters, and the judge declared provisions of the Elections Act, that is Section 18, provisions of the Elections General Regulations 2012 as amended in 2017, that is Regulation 18-2C, Regulation 24-2C, 28 2C, and 36-2C, unconstitutional and discriminatory. The judge also quashed the regulations as amended. But as you know, the law does not act retrospectively. If it did, then the judge ought to have specifically ordered and directed the commission to register those persons who did not qualify for want of compliance with those regulations. But there is no such a positive order directing the Commission to clear those aspirants. So the law applies moving forward, and the Commission is guided. The Commission has a feeling that that judgment is not sound with respect, and has filed a notice of appeal in that respect, and is applying for a stay of execution of that judgment for valid reasons, because the Commission believes that it is not a well-grounded judgment based on constitutional principles and based on the provisions of the Elections Act. Thank you, Chair.
So, thank you, Owiye. Just to add on that, the impression that the Commission makes the regulations and has its own laws is what's trending. I also follow social media. Now, that's not true. What the Commission implements is the Constitution, the Elections Act for purpose of elections, and the regulations which are in that act. Now, regulations are passed by Parliament and approved and passed by Parliament. So we follow the law as then laid down by the people of Kenya in the Constitution, and the laws which are then passed by Parliament. So in all we do, and at the time we are clearing candidates, we followed the Constitution, the election law, and the regulations that were in place that time. And they were constitutional that time. So we did not create our own laws, as it's being, the impression is being given around. Thank you. Do you have any other questions? We can start with you, Veronica.
My name is Emmanuel Chok from KTN News.
Yes.
Just a quick follow-up question. There were reports that Ford Kenya leader Moses Wetangula is related to one of the printers in Greece. I know you answered it partly, but what would be your answer to it again? And secondly, follow up on the comments about the manual and electronic voter register. What would be your direct answer to Raila Odinga, who said no manual voter registration, no manual voter register, no election? Thank you.
Yes.
Chairman, thank you for this opportunity. We want to confirm that Kenya Kwanza and UDA are also taking part in the visit that has happened this morning, mid-morning, at your warehouses where the KIMS kits are being loaded with the registered voters. And Chairman, we hope that the team, all the teams, all the stakeholders will develop a protocol on how those visits will be conducted and how issues raised by stakeholders will be handled. For instance, if there are any concerns raised by political parties, what is the turnaround time for taking up those issues and implementing them, so that we don't carry forward baggage as we move towards 9th of August. We would also request the Commission that all our communication, especially from Kenya Kwanza UDA, that you respond to it timelessly and that action is taken to forestall any obstacles that may make it a little bit more difficult for the operation of your plan towards the 9th of August. Sometimes we know the Commission is overwhelmed, but it's taking a little longer than expected to respond to communication. So we hope that can be improved going forward. Once we have a protocol which is agreed among all the stakeholders, it becomes easy for parties to understand that if the visits are happening on Thursday, is it available for people to go there on Friday or on Saturday? If an issue is raised, who will be responding to us in a timely fashion, whether those issues have been canvassed. Regarding that issue number one, regarding also the issue of the presidential candidates, the ballot paper, I believe, is now going on print for the presidential elections. So we are assuming that in spite of the judgment that was given by Justice Murima, that moving forward, we have the 4 candidates on the ballot, and it is confirmed to avoid sending confused signal to Kenyans regarding the number of presidential candidates on the ballot. On the question of complementary system, that is section 44A, Chairman, this is an issue that is getting misty by the day, and you need to come out more clearly on how this identification system will work on 9th of August 2022. I think the Commission need to confidently inform Kenyans and advise Kenyans that identification will be through the KIMS kit at the door. I think we are getting more confused. That's the primary mode. That's what we discussed at Windsor. The primary mode of identification will be through the KIMS kit, so that people don't go to the stations on 9th of August thinking that they are going to be identified using the manual register. That is not the primary mode of identification on 9th of August 2022. Chair, I think you need to come out clear together with the commissioners on what is the primary mode of identification. And if the manual register is used, what is the protocol for using that manual register? Do we say that we'll have 100 people walking in and they're not being found in the KIMS kit? Their data is not available on the identification system, the electronic identification system, and then we are reverting back to the manual system, so that we don't send a confused signal that we are using the manual system for the 9th of August 2022. I think those are the issues I would want to raise with the Commission.
Okay, thank you. We can deal with those ones.
My name is Givas Mbaina from K24. And for us not to misreport